Welcome in. I'm Mugo Odigwe. We have all eyes on the Supreme Court this morning for their last day in session. We know justices handed down their final 6 decisions, and they include some landmark cases. So let's break down which legal showdowns we are watching. Perhaps biggest of all, a bombshell opinion that gives President Trump a win in his bid to enforce his executive order. And that order denies birthright citizenship to U.S.-born children who have parents in the country illegally. Now, notably, it was a partial stay on the nationwide injunctions against the Trump administration's actions, but not a ruling on the merits of birthright citizenship. More on that in a bit. And a win for Maryland parents in a religious rights case over LGBTQ storybooks in public schools. The court says they can pull their children from public school lessons that use LGBTQ storybooks in those lessons. Let's begin there with CBS News chief legal correspondent Jan Crawford. Jan, thank you for joining us today. I know a busy day as the Supreme Court puts out those rulings. The justices didn't rule on the merits, as we said, of birthright citizenship, but this is still very much a landmark ruling. Can you take us through the decision and what it means?
Yeah, and you're so right to kind of point that out right at the top, Mugo, because there is a lot of confusion about this case. And it was part of a challenge to that executive order on birthright citizenship that President Trump issued on day one. When people filed lawsuits against that executive order, three federal judges, one in Washington State, one in Maryland, and one in Massachusetts, didn't just rule on the issues involving the parties and the states before them. They made their rulings apply nationwide across the board to everyone. So that was the issue in the case. Can one federal judge essentially dictate policy nationwide? And in its opinion today, 6-3 ruling by Justice Amy Coney Barrett, the Supreme Court said this is not how the system was set up to work. Congress did not authorize this. Federal courts don't have this kind of, federal judges don't have this kind of broad power to enter these kind of injunctions. And, you know, any case that they think it is important, you have to go through processes. There are ways to get nationwide injunctions, but you got to do it the right way. You got to do it a different way. So, you know, this is a big win for President Trump, no doubt. But it's also a win for all presidents because President Biden asked the Supreme Court to do away with these things. President Obama complained when he was in office about these kind of nationwide injunctions because what happened when a Democrat's in the White House is that Republicans go and, you know, conservative states like Texas find a judge who's sympathetic to them and get that judge will enter an order blocking their initiatives on immigration or student debt loan relief or COVID mandates. So we saw that throughout the Biden administration. So today the court is saying, no, not in every case. You can get nationwide relief, nationwide injunctions, but you got to do it the right way, like maybe file class actions, for example. So that means that this case, while really significant legally in terms of the process and kind of putting the brakes on this relatively new thing we're seeing federal judges do, it really might not have any practical implications for those challenges to birthright citizenship, because I expect that in the states that now, you know, where the litigation hasn't been to the point where judges blocked it, you're going to see lawsuits seeking class action status where people will be able to pretty quickly block this executive order indefinitely. I do not expect this executive order to ever take effect.
But Jan, when it comes to the nationwide injunctions question of all of this, what does this ruling mean for the balance of power between the president and then the judiciary?
Well, according to the Supreme Court and the presidents over the last 10 years, these federal judges are exceeding their authority. And that's what the court ruled today, that, you know, there's Congress authorized federal courts to have this kind of jurisdiction back in 1789. It was never part of what they were authorized to do, which means Congress can always go back and change the law if they want to, which obviously they're not going to do. The reason this has become such an issue over the last 10 years is because Congress doesn't do anything. They're totally dysfunctional. They don't, you know, fix the immigration system. They're unable to make any decisions. So presidents, you know, as Obama did, as we see, they feel like they've got to step in and issue executive orders, whether it's on immigration like Obama did with the Dreamers. And so that's what then, you know, federal court judges who are perhaps a different ideology are trying to put the brakes on. So yes, presidents have been starting to exert more authority with executive orders. Judges have then asserted more authority that the court today said they don't necessarily have. And whose fault is all of this? If Congress would do its job, we wouldn't even be here talking about this right now, Mugo. But I can say that with almost every case.
I mean, that is a good point, a very, very good point indeed. I want to ask you about the dissenting opinion, those minority opinions. What are your thoughts on them? We're looking at something here on the screen from Justice Ketanji Brown Jackson. It says the court's decision to permit the executive to violate the Constitution with respect to anyone who is not yet sued is an existential threat to the rule of law. Wanted to get your thought on that. We also have another opinion here. This is from Justice Sonia Sotomayor. It says the government does not ask for complete stays of the injunctions as it ordinarily does before this court. Why? The answer is obvious. To get such relief, the government would have to show that the order is likely constitutional. Again, wanted to get your thoughts on those opinions from the justices.
Yeah, and Justice Barrett answered that in her majority opinion, suggesting that there are other ways that people could get this kind of relief that would apply nationwide and, of course, can act very quickly. That's why I don't think you're going to see this order ever being implemented, because every judge that's taken a look at it has said what Trump is suggesting here is blatantly unconstitutional. The liberals and Justice Kagan among them are saying that if there was ever a case to have a nationwide injunction, it's this one. So what are you doing? Majority decisions. And Justice Kagan made that point at oral arguments. She had been critical during the Biden administration of these nationwide injunctions. In fact, she said during a talk in 2022 at Northwestern Law School that it just can't be right, as she put it, that one federal judge can essentially grind to a halt a president's initiative and keep it blocked indefinitely. So that was in 2022. Now she says at argument but there may be one case or two cases or a few cases where that would be okay. The concern with that the other justices have, Mugo, is that every federal judge that gets an issue is going to say, this, of course, has nationwide importance. This, of course, could affect, thousands or hundred thousands of people across the country. So I'm going to enter a nationwide injunction, too. There will be no real teeth to that. And that's why the majority declined to kind of carve out those kind of like in the big, really big case that'll affect everybody. They refused to do that kind of exception. They said there's other ways to get it, just like drive a different car to the courthouse, so to speak. File a class action. You can get a nationwide injunction that way. And that's what I think we'll see starting next week.
Yeah, and Jen, I have to ask personally, because if this has been a problem with the Obama administration, the Biden administration, and now the Trump administration, why has it taken this long for the Supreme Court to have to decide on it?
That's a great question, and the court should have taken this up back in December of 2024 when the Biden administration's Justice Department asked it to. Trump also complained about it in his first term. And so why did it have to wait until this case to do it? I think there's 2 points. The judiciary system typically, the Supreme Court, they like to be a court of review, so that they typically take cases where lower courts have divided, where they're split on an issue. And so we haven't had a lot of writings in the lower courts on whether or not this is a good idea or a bad idea. We've just had a lot of lower courts saying nationwide injunctions, let's go. Because like I said, conservatives like nationwide injunctions when, the Democrats in the White House. So, you haven't had people necessarily challenging them. And we did have it in this case. We have a dissent, a dissent in the Maryland case. A federal appeals court judge said these nationwide injunctions are totally inappropriate. So who knows why they decided to take this one? There are other technical reasons, I think, that they agreed to do it. But the point is they're sharply putting the brakes on these things. And as you said at the top, the bottom line, this does not impact, I do not think, it is not about the merits of nationwide citizenship. It does not mean that Trump is right about that. And in fact, Trump is not right about that, as every single court has said. So I think there's nothing in today's ruling that means that executive order will be implemented, and people are going to have to start showing citizenship papers in the maternity ward. I don't see that happening.
Okay. And there is another major ruling on the use of LGBTQ-themed materials in schools. What did the justices decide on that case?
You know, this is one of the bigger cases of the term as well, and it's one that I think you can have, you know, one of these cases where you can kind of have sympathy for both sides. Both sides of parents came in. It came about when a school district in Maryland, in Montgomery County, which is just connected to Washington, D.C., very progressive county, they said, you know, this is life. We need storybooks that feature, you know, a gay dad or a gay couple. So they worked to try to introduce half a dozen or so books into the curriculum. Then you have parents with deeply held religious views, many of them immigrants, who said this goes against my religious beliefs. And so that's how the case got to court. They sued, saying not to ban the books, but just that they wanted to be able to opt out their children, elementary school children, when these books were being read during story hour. The reason I knew the parents were going to win this case, that with the religious objections, which they did in an opinion 6-3 by Justice Alito, the parents won. They will be able to opt out of these lessons, is because the justices read the books. Initially, it kind of been presented as, you know, this is just LGBTQ characters and themes, but some of the books the justices suggested oral argument go way beyond that and actually like indoctrinate kids to believe, they said, that you get to pick your gender, that gender is fluid. And Justice Alito, in his opinion, has actually attached copies of the pages that they're referring to. So that, I think, means and helps us think about this case, it's probably going to be a pretty narrow case. I don't think it'll have any impact on anything involving, like, could you opt out of history lessons or other lessons. My guess is it was just the nature of the facts of this case and some of the books that they were using, and that's what drove some of the objections, and I think that's what also drove the majority decision in this case.
Okay, CBS News Chief Legal Correspondent Jan Crawford, thank you so much for walking us through all of that and for your analysis. We really appreciate it. Let's turn now to CBS News legal contributor Tom Dupree. Tom, thank you for joining us today. I want to ask about that ruling about the nationwide injunction. How does it affect the balance of power between the presidency and the judiciary?
It's an enormously important opinion, and it does redefine the balance of power between the president and the courts. The Supreme Court basically said that a single federal judge generally does not have the power to issue a nationwide injunction, which can freeze a president's order in its tracks across the United States. I think one consequence for this is going to be you're going to see a lot more litigation, because the Supreme Court basically said if you are trying to get an order that stops a president's action across the country, you basically have to file either a class action lawsuit or just a lot of individual lawsuits. So there is still the possibility of getting an order of this scope, but the Supreme Court made it far more difficult to do so, and in a way that will benefit the power and increase the power, not just of President Trump, but of all the presidents that follow him.
And we understand the Trump administration, they took this case to the Supreme Court asking about birthright citizenship, but then the question was really narrow. Why do you think they chose to do that?
Well, Justice Sotomayor accused the Trump administration of gamesmanship. She said that the reason why the administration only went up to the Supreme Court on the question of the nationwide injunction and not the question of birthright citizenship is because they didn't want the court to decide the constitutional question of birthright citizenship, at least at this point in time. So from Justice Sotomayor's perspective, the administration made a strategic decision to avoid getting a ruling on the merits of whether what President Trump did is constitutional. So that question is one that will continue to be fought out in the lower court. So far, pretty much every court has rejected it, but ultimately, someday it will wind up making its way to the United States Supreme Court for a final decision.
All right, Tom Dupree, thank you for your analysis. Appreciate that.
Thanks.
And now let's bring in CBS News Justice correspondent Scott McFarland, who is at the Supreme Court. Scott, thank you for your time today. Can you break down what this ruling means when it comes to the power of the judiciary to check the powers of the president?
That's a victory for the administration now and future presidential administrations that don't want to see any controversial executive orders or rulings against them from the courts in their controversial executive orders. That notwithstanding, it's especially impactful at this moment because as of this week, as of the end of this week, there are more than 450 lawsuits challenging Trump administration decisions, personnel moves, or executive orders. A lot of footholds for the court to get involved and issue injunctions. That notwithstanding, some of the states are part of those efforts to challenge the Trump administration in court, and it's unclear that this ruling would stop a coalition of states from trying to get a nationwide injunction from the court system. But it's also part of a bigger issue here, isn't it? There's a political issue the administration has been trying to mechanize in its criticism of court rulings, saying that the courts are stopping the will of the voters, that the courts are slowing the administration from trying to execute immigration enforcement, new border security initiatives. They have been a foil, the courts have, for the administration's political goals, and this means this ruling is quite a victory for the administration.
And Scott, I want to pivot to a different topic here because lawyers for Kilmar Abrego Garcia, they have just asked a judge to keep him in federal custody. Can you give us an update on this case?
Yeah, speaking of the courts, there's that matter of Kilmar Abrego Garcia, who really has become the face of this battle between the administration and the court system in Nashville, where Abrego Garcia is charged with federal human smuggling charges. His lawyers have said they want him to remain in pretrial detention in Tennessee. That is a unique argument for a defense attorney to make, but they're citing some conflicting guidance they're getting from the administration. Some people in the administration say they want to deport Abrego Garcia to a third nation, not El Salvador. And there are others in the administration saying no, they want to keep Abrego Garcia as they continue with that federal criminal prosecution in the Middle District of Tennessee. Amid all that lack of clarity, the defense says, let's just keep him where he is now for a couple more weeks and continue this battle in the courts.
All right, Scott McFarland at the Supreme Court for us. Thank you so much for that update.